Turning now to Donald Trump's lingering legal troubles, only days after the president told reporters aboard Air Force One that he was not aware of the payment his personal attorney, Michael Cohen, paid to porn star Stormy Daniels, a motion has been filed by her attorney to depose Mr. Trump and Cohen. Will such a deposition happen? And what does the president's remarks on the payment mean for the case going forward? Let's get legal assessment from Kendall Coffey, former U.S. Attorney for the Southern District of Florida. And here in studio is Trent Copeland, criminal defense attorney and legal analyst, very well known in Southern California and across legal circles across America. All right, Kendall, Trump said he was not aware of the payment to the Stormy Daniels. If he wasn't aware, how can he ask her to pay $1 million for every time she talks out?
Well, the theory that is being advocated by Trump's lawyer, Michael Cohen, is that it was a third-party beneficiary agreement, which the law recognizes. That is to say, yeah, Trump didn't sign it. Apparently, according to them, Trump didn't even know about it. But if another party enters into an agreement for the benefit of a third party, the law can frequently enforce that. That'll be the big issue, I think, for the judge to determine. Can somebody be a beneficiary of a binding agreement even if they have no idea it ever happened?
Trent, what do you think?
I don't think it goes anywhere. I really don't. It's like this third-party beneficiary, remember, this is the second stab at trying to make this agreement a good agreement, right? The first one was it's an agreement, David Dennison is Donald Trump, and you got to abide by this hush agreement. This is a little different now. Now they're taking another stab at it. This is, okay, since Donald Trump didn't sign the agreement, Donald Trump isn't allegedly David Dennison, he's a third-party beneficiary. But under California law, Larry, California law requires that if you are a third-party beneficiary to a contract, you have to be named in the contract. You also have to assent to the contract. That means, look, you just got to agree to the terms of the contract before you can accept the benefits of the contract. And look, that makes a lot of sense, right? If you sell insurance and I want to buy insurance from you and I want to insure that cameraman has to agree at some point once he learns of the insurance proceeds, he's got to agree at some point that he's going to be bound by it. So look, this isn't one of these things that I think is going to go very far in terms of the legal ability of Trump and Cohen to move forward with this.
Kendall?
Well, I think that what the judge is likely to do is first order a deposition of Michael Cohen. Yeah. That seems like the logical starting point, just to get his side of everything before the judge goes to the next step to determine whether or not the President of the United States will appear for a deposition, which is being proposed to be 2 hours. Those things the judge is going to look down the road at pretty soon, and then after hearing from whatever information both sides have, the judge will decide whether there's going to be a jury trial on the enforceability of the agreement. So I think Cohen's deposition is going to be ordered. I think that's going to determine whether or not the president also sits for 2 hours and answers questions under oath.
Kendall, if this is so perplexing, do you know of any lawyer who would pay $130,000 for a client and the client doesn't know about it and it's the lawyer's own money?
Well, that would be pretty unusual. I was trying to think through my own experiences, and I certainly haven't done anything like that. And I was intrigued that Cohen had indicated there were no bar issues with it, because if you are acting for somebody's benefit in an attorney-client capacity, of course you've got to tell them about a settlement. I suppose that the thesis here is that he did it on his own for a good friend, not acting as an attorney, and because he thought it would somehow benefit the common good to do it. Let's just say it's very, very unusual.
Why didn't he do it under his own name?
Didn't do it under his own name because he was doing it in the capacity of attorney-client relationships. And he did this because it was hush money. He did this because he didn't want anyone to know. I've never heard of it. This is outrageous, the very suggestion that he did this as a good friend and he didn't even tell him. And he wanted him to be benefited by it, but he was a good friend and he paid it out of a home equity loan. None of this adds up, Larry.
That makes no sense.
None of it makes any sense.
Kendall, what's your assessment of how Mr. Mueller is doing?
I think prosecutors would give him very high marks for a lot of reasons. First of all, is if you think about it, he's already brought into the prosecution fold two very high-value cooperators, Michael Flynn, Rick Gates, both of whom have had significant proximity to the president, plenty of connection to Russia, and now they have plenty of reasons to try to incriminate others. I think if you look at the Manafort indictment, if you look at the indictment of the Russians who are allegedly infiltrating illegally social media, those are so detailed and so impressive just from putting the facts together with various far-flung international data points. They look masterful from a prosecution perspective. So I think very high marks from prosecutors. Of course, he's not finished yet, and constitutional scholars will want to see where he ends up on some critical points before they give him the same high marks.
You think, Trent, that Paul Manafort might put the FBI on trial as attacking them, paving the way for a pardon?
I do, and remember the old adage, Larry. You know this as well as anybody. When you're a lawyer and you don't have the facts, you argue the law. And you don't have the law, you argue the facts. In this instance, I don't think they have either. So they're going to put the FBI on trial, and they're going to put the entire judicial system on trial. So I think really Paul Manafort may be a linchpin and a key to this. But look, he's holding out. Right? He's a man in his 70s. He's looking at a substantial amount of time if he's convicted on all of the counts. And so for him, he's got really nothing to lose. His viewpoint, I believe, and I think he's probably received a signal from the Trump organization and the Trump orbit that there's probably going, if he can hold fast and he can stay true to the team, there's probably going to be a pardon for him down the road.
Kendall, Trump's attorney has been informed that the president is currently a subject but not a target of the inquiry. What does that mean?
Well, to be a target in the federal jargon means that there's a probability that you will be indicted. So that's somewhat good news, but it's not the last word. And they're still pressing hard for an interview. By the way, they could seek to subpoena the president to a grand jury, provoking perhaps a lot of constitutional uncertainty. But one way or another, Mueller wants to talk to the president. And that, I think, poses the biggest dangers of all. Because we all know that if there are material false statements during the course of that interview, then that becomes the crime of obstruction. Whether or not it's federally indictable against a president, others might have to determine. But certainly, I think the interview is the most perilous part of all of this for President Trump.
You think Trump will sit down with Mueller, Trent?
Larry, I think he has to sit down with Mueller, not just because I think he has indicated in public that he wants to. You know, he's got a pretty brash, bravado attitude towards this, and I think he believes that he can probably, outdo Mueller and his team of prosecutors. That would be a mistake, but I think Donald Trump is thinking in that direction. But Larry, not just because Trump wants to, or at least he's indicated publicly that he will, I think the law requires that he'll have to sit down with him. If Mueller persists in this, remember, under Clinton versus Jones, under United States versus Nixon, a president must sit for a deposition or any kind of arrangement where he has to provide testimony. He must do so under federal law. So, look, I think he's going to. I think he's going to sit down. I don't think it matters whether or not he does it under oath, whether he does it not under oath, because under 1001, if it's a false statement, the same thing that Martha Stewart went to jail for, if he tells a false statement there, that's a false statement. Under 1621, under the U.S. Code, it's perjury. So either way, whether he's under oath or he's not under oath, if he gives a false statement, he's going to go to jail.
Kendall, do you agree?
I agree that he's going to end up sitting down, and one of the big things he's going to have to come back to is James Comey. James Comey is somebody that the prosecution team is going to believe, absolutely. He's a former colleague. They have no reason to think he's got a motive to lie. If President Trump comes in and makes serial denials of specific things that Comey says, the president told me this, then what you've got is more than a he said. You've got a James Comey, who they're inclined to believe, being flatly contradicted, as Trent pointed out. Whether it's a false statement under oath or not really doesn't matter. If the president is flat out contradicting Comey, I think there's going to be real problems.
And if you were the president's lawyer, would you try to get him out of that deposition, Trent?
I don't think that I would, and I don't think there's any way he's going to, because he just doesn't have the law in his favor. At this point, that horse has left the stable.
Thank you both very much. Thanks, Kendall.
Thank you,
Hey,
Larry.
thanks,
Thanks,
Larry.
Trent.
You bet.